Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Imagine looking at just a breathtaking, award-winning photograph. Like, the lighting is absolutely perfect, the subject is striking, and the composition just draws you right in.
Oh, yeah. The kind of image that really grabs you.
Exactly. But then you look down into the bottom corner and you see a faint, semi-transparent Getty Images watermark.
Right. Which totally shifts your perspective.
Yeah, it does. But here is the catch. Getty Images has absolutely no record of this photo.
None at all.
Because it wasn't taken by a human. It was generated by an AI, like an AI that essentially just accidentally confessed to what it was studying.
It's the kind of thing that makes you do a double take, you know? Your brain processes that watermark and says, well, oh, this is an official stock photo.
Right.
But the underlying technology is doing something entirely different. It's generating that mark completely out of thin air.
And that bizarre visual glitch is the doorway into what we're tackling today. Welcome to the Deep Dive. We're pulling from a really fascinating piece titled When AI Art Looks Familiar, and our mission today is to explore how the courts are actively trying to untangle this incredibly messy web of copyright and trademark claims in the age of generative AI.
Oh, it is quite the web.
It really is. So we're going to follow the high-stakes legal battle between Getty Images, the massive photo licensing agency, and Stability AI, the makers of the Stable Diffusion image generator.
And we really need to set the stage here because this isn't just some niche Silicon Valley tech dispute. What you're witnessing is a real-world collision of eras.
Well, for sure.
We're watching centuries-old legal concepts laws, literally designed around the invention of the printing press and physical human painters, slamming headfirst into cutting-edge technology. Technology that operates in ways the law never even anticipated.
Okay, let's unpack this.
Yeah.
Because when you or I see an AI image that looks virtually identical to a stock photo, the immediate gut reaction is, well, the AI just copied it, right?
Right. Of course. That's what anyone would think.
Right. The assumption is that it went into some massive server, grabbed a protected image, and just spit it back out with a filter on it. And that was the core of Getty's initial claim.
Yeah.
They alleged that Stability AI trained Stable Diffusion on millions of Getty's copyrighted photos without permission, making the outputs infringing copies.
Which, sounds completely logical. If I take your physical photograph, run it through a scanner, and use it in my magazine without asking, I've infringed on your copyright.
Right, exactly.
But this is where the legal theory just crashes into technical reality because Stable Diffusion doesn't actually store copies of the training images inside its model.
Wait, really?
Yeah, there is no hidden folder of Getty JPEGs sitting inside the software just waiting to be mashed together.
Right, so it's not a digital scrapbook. But if it's not storing the images, what exactly is it doing? Like, how does it know what a Getty image looks like?
Well, this is where we have to talk about how these models actually learn. They use a process called diffusion, which operates in something called latent space.
Okay, you're going to have to translate that for me. Latent space.
Think of latent space as a massively complex, multidimensional map of concepts. When the AI is training on Getty's images, it isn't saving the pixels.
Okay.
It's taking an image, gradually adding digital static or noise to it until it's just a blurry mess, and then it learns the mathematical steps to reverse that process.
Oh, wow.
Yeah, it learns how to denoise the image back into a recognizable picture based on the text tags attached to it. So it's mapping the relationship between the word dog and the visual features of a dog. It extracts mathematical rules, not literal copies.
So let me see if I'm wrapping my head around this technical roadblock properly. Is this basically like an art student going to a museum?
Okay, let's hear it.
Imagine an art student studying a million different paintings by a specific artist. They sit there for months absorbing the brushstrokes, the use of color, the way the light hits the canvas, and then they go home and they paint a brand new picture in that exact same style from memory.
Right.
They didn't use a photocopier on the original painting, they just learned the pattern. Is that essentially how the court is viewing the AI?
It's a tempting analogy, but it completely breaks down when you consider scale and mechanism.
How so?
Well, an art student doesn't ingest 5 billion images in a few weeks and then regurgitate them on demand for a subscription fee.
Yeah, fair point.
When a human learns, we call it inspiration. When a machine does it at a planetary scale, it's industrial data extraction.
Wow, yeah.
But, and this is the crucial part, under current law, the courts are treating it a lot like your art student.
Wait, they are?
Yeah. In November 2025, the UK High Court handed down a ruling on this exact issue. They found that AI model weights, the underlying math dictating how the AI generates an image, are the product of learned patterns, not stored reproductions.
Because the original images are technically gone.
Yeah.
Only the mathematical memory of the style remains.
Precisely. And because of that technical distinction, the court ruled that these weights cannot be treated as infringing copies under UK copyright law. Copyright law historically protects the specific expression of an idea, the actual painting or the specific arrangement of pixels in a photograph. It doesn't protect a mathematical pattern or a generalized style.
I see.
Plus, Getty had a jurisdictional snag in this specific case. They conceded that the actual training of the AI took place outside the UK, which severely weakened their ability to argue copyright infringement in a British court.
Okay, I hear the technical explanation, but I have to push back a little on how the law is justifying this.
Sure, go ahead.
If the output from the AI looks practically identical to a Getty image, say it has the exact same framing, the same subject, the same lighting, how does the law justify saying no infringement happened just because of the way the file is saved?
It's a tough one to swallow.
I mean, whether the machine stored it as a JPEG or stored it as a complex network of mathematical weights, the end result is that Getty's creative work is being reproduced, isn't it?
It's a completely valid frustration, but you have to remember the law cares deeply about the mechanism of the alleged theft. Think back to the invention of the VCR in the 1980s. The film industry tried to sue Sony, arguing that the VCR was basically a piracy machine.
Right, I remember hearing about that.
But the Supreme Court ruled that because the machine had substantial non-infringing uses, like time-shifting a TV show to watch later, the technology itself wasn't illegal.
So the tool isn't the crime.
Right. And here, copyright infringement usually requires an actual literal copy to have been made and distributed.
Which they can't prove.
Exactly. Because the model weights are just numbers dictating probabilities in that latent space we talked about, the court couldn't find a literal verifiable copy within the software. Proving copyright infringement when an AI model merely resembles a protected work without provable pixel-for-pixel copying is extraordinarily difficult.
Which means copyright law basically hit a brick wall. Getty's primary weapon was neutralized by the sheer complexity of how the AI stores data.
Yeah, they're in a tough spot.
They couldn't prove a stored reproduction existed, so they had to find a completely different legal door to open. And they found it in the weirdest possible place.
The watermark.
Yep, that ghost-like watermark I mentioned at the start of the deep dive.
What's fascinating here is the sheer brilliance of the strategic pivot Getty made.
Oh, yeah.
When copyright failed to protect the underlying art, they didn't give up. They shifted gears entirely and leaned on trademark law.
Here's where it gets really interesting.
Yeah.
Because the AI essentially turned into its own worst witness.
It really did.
Users started noticing that when they prompted Stable Diffusion to create certain types of images, the outputs were displaying a garbled, yet still highly recognizable version of the Getty images or iStock watermarks.
And this changes the entire legal conversation. We've been talking about copyright, which is fundamentally about protecting the creator. It's about who owns the labor and the expression of the underlying photograph.
Right, the art itself.
But trademark, on the other hand, is completely different. Trademark is about protecting the consumer. It's about brand identity and preventing consumer confusion in the marketplace.
So think about it like buying sneakers. If you buy a pair of shoes with a Nike swoosh on them, trademark law exists so you can trust Nike actually made them.
Exactly.
If another company puts a fake swoosh on a terrible pair of shoes, it hurts Nike's brand because consumers are confused.
Exactly. So Getty's new argument was essentially, forget about whether you copied the pixels of our photos. Look at what your machine is outputting. It is stamping our company's logo onto images we didn't create, and it's confusing the public.
Which is the ultimate irony.
Yeah.
The AI studied the training data so thoroughly that it learned what a professional stock photo looks like. And because millions of high-quality stock photos have a Getty watermark on them, the AI's internal logic essentially concluded, to make this look like an authentic stock photo, it requires this weird text in the bottom corner.
Yep. Just learn the associate.
Yeah. It learned the pattern of the watermark so well that it incriminated itself.
It really did. The AI doesn't know what a watermark is. It doesn't know it's a legal claim of ownership.
Right. It's just math.
It just knows that in the data it was fed, a specific cluster of pixels in the bottom right corner is highly correlated with the pumped professional stock photo.
Wow.
And legally, Getty argued this creates a massive problem. If a user sees an AI-generated image with a garbled Getty watermark, they might mistakenly believe Getty produced that image.
Which hurts the brand.
Exactly. Or worse, they might assume Stability AI has an official licensing relationship with Getty. Neither of those things were true.
So the argument fundamentally shifts from "you stole my art" to "you are tricking the public into thinking we are associated." It's a claim about false association, brand damage, and consumer confusion.
Precisely.
But, Getty making a clever argument is one thing. Whether it actually holds up in a court of law is another. Did it actually work?
Well, the answer to that depends entirely on which version of the AI you are talking about.
Oh, really?
Right. The UK court came back with a split decision on this trademark issue. They actually agreed with Getty, but they drew a very hard line between the early days of the software and its current iteration.
So they looked at the early versions of Stable Diffusion.
Right.
And found that when you gave it a realistic prompt, it absolutely did generate images containing those recognizable Getty or iStock marks.
Yeah, the evidence was right there.
And the court agreed that this created a genuine, actionable risk of consumer confusion. So for those early models, Getty's trademark theory completely held up.
It did, but then the court looked at the later versions of the model.
Right.
Obviously, Stability AI realized what was happening pretty quickly.
Right.
Having your AI hallucinate a competitor's logo is a bad look.
Yeah, not great for business.
So they implemented better filters. The court found that for these later, quote-unquote, better filtered versions of Stable Diffusion, Stability AI was largely let off the book.
Wait, why? Just because they slapped a filter on it?
Because Getty couldn't provide sufficient evidence that these newer models were actually reproducing watermarks out in the real world under normal use.
So the filter worked.
The filtering was good enough to eliminate the immediate trademark risk. If the consumer doesn't see the watermark, there's no consumer confusion. And if there's no confusion, there's no trademark infringement.
Which brings up a highly practical and honestly slightly cynical question.
Let's hear it.
If the later versions were let off the hook just because the output was filtered better, does this mean AI companies don't actually have to stop training on copyrighted images? Do they just need to build better watermark erasers into their systems to avoid lawsuits entirely?
That's the big question.
Like just sweep the evidence under the rug before it hits the user screen?
That is the exact tension this ruling highlights, and it's a brilliant question. From a purely functional standpoint, yes, a perfect filter solves the immediate trademark problem. But for AI developers, this ruling changes the game fundamentally. Filtering and training data provenance can no longer be viewed as just public relations concerns or quality control measures.
Right.
They are now strict legal liabilities.
Meaning if your filter slips up even a little bit.
Exactly. If your filter fails, you aren't just getting bad press on Twitter. You are actively committing trademark infringement. You are legally on the hook for brand confusion.
And it's really important to note that this is not just a UK issue. There's a parallel case happening right now in the U.S. federal court systems.
Oh, yes, very important.
They're testing very similar theories, like trademark infringement, false designation of origin, and trademark dilution. And a judge in that U.S. case recently allowed those claims to move forward to discovery. So this legal strategy is getting serious traction on both sides of the Atlantic.
And that U.S. case is going to be crucial to watch. U.S. and U.K. courts don't interpret intellectual property law exactly the same way.
Right, there are differences.
The U.S. has a very robust doctrine of fair use, which often gives tech companies more leeway to use copyrighted material for transformative purposes.
Sure.
But trademark law is a different beast entirely. The fact that the trademark claims survived a motion to dismiss in the U.S. means the federal courts believe Getty's argument has real legal merit. It's not a frivolous claim. It needs to be explored in a full trial.
Okay, let's unpack this. So what does this all mean? If you're listening to this and you aren't a high-powered lawyer for a massive photo agency or a machine learning engineer at a billion-dollar tech company, why should you care about this specific ruling?
It's a fair question.
Because to me, this case feels like it's setting a strategic precedent that's going to ripple through how the entire digital economy operates going forward.
If we connect this to the bigger picture, this case provides the new legal blueprint for the AI era.
The blueprint.
When copyright claims stall out, because As we saw, AI outputs rarely count as literal, pixel-for-pixel copies. Trademark law is officially the new weapon of choice. The fundamental legal argument in the tech world has evolved. We are moving away from the debate of, you stole my image, to the much more actionable claim of, your tool is creating consumer confusion about who made this.
Which is a massive warning sign, or like a live risk for literally any business out there.
Absolutely.
Think about your own company or your own personal brand. If your identity relies on visible marks, if you use specific logos, distinct color combinations, or watermarks to protect your work or identify your products, you are suddenly on the front lines of this issue.
Yeah, you're in the crosshairs.
If an AI generates something that even hints at your logo and a consumer gets confused, you now have a legal avenue to fight back. And the best part, you don't have to prove they stored a copy of your work on their hard drive. You just have to prove the output is confusing.
Exactly. It shifts the battlefield from what happens inside the impenetrable black box of the AI to what comes out of it.
That was so much easier.
Yeah, it's a much easier case to prove when the evidence is sitting right there on the screen. But, you know, as we wrap our heads around this shift, we also have to acknowledge the massive, unresolved elephant in the room.
The actual training itself.
Precisely. The biggest question of all remains completely untested in this specific UK ruling. Is the sheer act of training an AI on millions of copyrighted materials, the scraping, the downloading, the analyzing, the adjusting of those mathematical weights in latent space, is that act itself an infringement regardless of what the AI outputs later?
And the UK court basically sidestepped that entirely because Getty conceded the actual server training happened outside their jurisdiction.
Right, they didn't even have to rule on it.
So the core existential caution for AI, whether tech companies are legally allowed to indiscriminately read, scrape, and learn from our data in the first place, is going to have to be sought somewhere else, probably in that U.S. federal court case.
Which means the battle over AI regulation isn't ending, it's just adapting. We are moving from debating what the AI takes on the back end to strictly policing what the AI outputs on the front end.
It's been a wild journey untangling this. We started with an AI's technical inability to copy a file, which led to a massive failure for traditional copyright law.
Right.
But then, because the AI hallucinated those garbled, ghostly watermarks, it gave Getty the perfect opportunity for a brilliant pivot to trademark law. And that pivot resulted in a fascinating split decision in the UK, punishing the early AI models for being sloppy, but letting the newer, filtered models off the hook while a massive parallel battle gears up in the US.
It is a wild journey, but this raises an important question, and it's something I want to leave you to ponder. We talked about how the newer AI models won in court because their filters were better at hiding the watermarks. Think about the logical conclusion of that. If AI developers eventually perfect those filters so that absolutely no watermarks, no logos, and no brand identifiers ever accidentally slip through into the final outputs, how will original creators ever be able to prove their life's work was used to train the machine in the first place?
Oh, wow. That is a terrifyingly good point. If they build a perfect watermark erasure, the evidence just vanishes.
Exactly.
If the ghost in the machine gets totally exorcised, creators might be left entirely in the dark with no way to prove their work fueled the algorithm. Well, thank you for joining us on this deep dive into the messy, constantly evolving intersection of art, technology, and the law. Next time you're scrolling and you see an AI image, maybe look a little closer at the corners. You never know a familiar ghost might be hiding in the pixels. Take care, everyone.